Call Alfred Naro.
Thank you, Mr. Chair. Mr. Chair, I rise to take a call on this bill, and we heard about the aspect of sense and common sense, but I think in some cases some of the members' points made were nonsense, in the sense that I was also part of that select committee, along with her and also to Mr. Little over there. We heard what they had to say. The regulatory impact statement declares this, that the aim of this bill is to create a modern, accessible family justice system that is responsive to children and vulnerable people. That's the intent. So do we care about children? Absolutely. Absolutely. It's nonsense to say that this government does not care about children. 386 written submissions, 217 is what we heard as the Select Committee, Mr. Chair. And here are just some of the comments, because I want to give a balanced view around the perspectives that have been shared today. So this is word for word from submissions that were shared at the Select Committee, a variety of different submissions. And so here's one of the submitters. This is what they said. This is not about the lawyers. I am particularly interested in the extent to which it is feasible to provide a positive conflict resolution assistance to families and laws and clients. I support the intent of this bill because I've seen money wasted on legal fees and family court time that could be better spent on helping parents, and here's the key point, and children. On helping parents and children. So you can't argue with that, because here's a submission from a submitter out of the 217, and this is what they're declaring to us. Mr. Chair, this is also really important. That was actually down in Christchurch, and Mr. Little was there as well. So this is what we want to say this. Mr. Chair, in the Select Committee, we've heard, we've listened, we've responded, and here are some of the recommendations. I want to pick up on the point around the counselling. We had relationship services who provide counselling services. When we asked them what were the number of sessions that they gave, so that we know they currently are contracted 4 sessions, this is what they said. The number of contracted sessions that they provide on average is 3 sessions. 3 sessions. So in response to that, we've also said, as a recommendation from the Select Committee, is to provide up to 3 hours preparatory counselling for eligible parents so they can make the most of family dispute resolution. Mr. Speaker, Mr. Chair, we are responding to what we are hearing out of the concerns. 3 sessions, 3 hours is what we're responding to. The other issue that we want to talk about, Mr. Chair, is about empowering the judge to be able to refer parties back to family dispute resolution, but also parenting through separation. Mr. Chair, I've sat through, I've also taken part in the family parenting through separation. I've seen the importance that that has had. Mr. Chair, we heard from some submitters who quite in an emotive state, and you've heard about that, it is an emotive state. Often when parents have got into that state, it's not about what's right, it's actually about what they feel within themselves. And all of a sudden, one of the submitters talked about, they just went into, and everything went red for them. They couldn't see the wood for the trees. All they saw was their sense of right. And what they forgot about was actually the responsibility of their children. The responsibility of their children. And so hence the reason the parenting through separation is absolutely important. It's been endorsed by those that have been through this course, who've seen the importance of the course. So parenting through separation, what does that do? It actually allows the parents to see the children, the voice of the children, the importance of the children to be taken into account in this issue as well. Mr. Chair, also too, one of the things that we've also too indicated as part of a recommendation of change is to provide up to 4 hours of legal support before entry into the court for parents who meet the legal aid threshold. Mr. Chair, one of the other areas that we think is absolutely important is to enable lawyers to get involved early in the court process at the judge's discretion. It would increase the chances of a successful resolution. Mr. Chair, what's really important to us is that the family disputes resolution has not only been endorsed by the arbitration and the mediators that came to make these submissions, but this is what they said to us, word for word. They said good arbitration, good mediation has the ability to be able to exit families out of the court system as early as possible. We know that the court system in itself is not only brutal, it's traumatic, but it's not the place where we want our children to be a part of. We don't want them to see their parents in the trauma of fighting against each other. We've heard that time and time again. So what we've heard again from the mediators, well-trained mediators through the family disputes resolution, are important to this process as well. So the bill establishes this family disputes resolution process to focus the family justice system towards supporting people to resolve their disputes where appropriate, and most importantly, out of the court system. Mr. Chair, the bill also requires a person to complete a parenting information program as well, and we see that as important. Thank you.
I'm going to call David Clendon.
Thank you, Mr. Chair. Mr. Chair, I'm pleased to take an initial call on this at this stage, and it was interesting to hear the Minister's comments